Okay. Right.
We have to wait for the gentleman.
Okay. Not a problem. I'll try to figure this out. It'll come to me.
Good afternoon, Detective Howard. Good afternoon. I want to continue discussing your assignment on the night of August 25th, 2021. Excuse me, before we took a
2020.
break. 2020, thank you.
Yep.
Before we took a break, you were talking about going on the internet and downloading some videos, and we're going to get back to that in a second. But I want to go back to the evening of early morning hours into the next day of August 25th, August 26th of 2020. Did there come a time in which you learned the identity of the person who had shot people that night?
Yes.
How did that come to be?
There was information on social media, and also we received information that the person had turned themselves in at the Antioch Police Department.
Prior to the defendant turning himself in at the Antioch Police Department, did you have information identifying him as the individual who shot and killed 2 people that night?
There were pictures circulating on social media.
Were you able to see or figure out the identity of the person in those pictures?
Early on in the investigation, I recall seeing a picture, but I do not recall knowing the identity of the person immediately.
Did there, after the defendant turned himself in to the Antioch Police Department, did you go down there in person?
Yes.
And did you have face-to-face contact with the defendant?
Yes.
Did the defendant indicate to you that he had suffered some injuries that night?
Yes.
Did you take photographs and document those injuries?
Yes.
Can you tell the jury about those injuries?
He had an approximately half-inch scratch above his left eyebrow. He had a small cut on the inside of his lower lip, slightly offset to the right. There is a approximately 2-inch scratch below his left collarbone. There was some redness to the right side of his belly button, just above his waistline. There was an approximate 2-inch scratch on his left forearm. There was some redness on his right forearm. There was some redness on the tip of his right thumb. And on his back, there was a scratch somewhere on his left side, about the where the left shoulder blade would be, in that approximate area. And also there were 2 bumps on the back of his head that was approximately here, so above the left ear. Both of those injuries on his head, I could not get to turn up in the photograph because Mr. Rittenhouse has very thick hair. But with the gloved hand, I was able to feel it. And both of these bumps I would approximate to be the size of a penny. And the skin was slightly raised, and I was able to feel that with my hands.
Was that the extent of the injuries that the defendant reported to you?
Yes.
Now, I know you talked about getting some videos off the internet. Was there a time in which you also collected some physical evidence from the scene of the shootings?
Yes, at 63rd Street and Sheridan Road, yes.
And can you tell us about that?
That was on August 29th. We had a citizen by the name of James Powarczyk. I might have gotten his last name a little bit off, but I think there were 2 W's in there. I think it was Powarczyk. We got a report from that the citizen came to check out the area of where this had happened, and he located 2 shell casings underneath a silver Chevy Cruze in the car source parking lot.
Karen, that last name is Piwowarczyk. After receiving this report, did you go to that scene to check out these shell casings?
Yes.
Did you recover those shell casings?
Yes.
And what were they specifically?
They were 2 Aguila 223 REM shell casings, and the location of where they were located, the silver Chevy Cruze was right in the area of what I had seen on the videos of where the shooting of Joseph Rosenbaum had taken place.
Thank you. Now, you mentioned earlier that as part of your investigation, you searched social media, the internet, et cetera, to gather videos of this particular night. Is that correct?
Yes.
Okay. I'd like to go through some of those videos now in your testimony. Let me turn the TVs on. Does that work for everybody? Is that not a good angle for you, sir? How does that work over there? Is that okay? Thank you.
Well, the problem is, once again, that I have to ensure that the defendant can see it.
He'll have it on his TV.
Oh, fair enough. Thank you.
The first video that I'm going to show is on our. Oh, I thought I hit the button. I apologize. This is a video which is on our list as exhibit number 18. And this is a video from a news source called The Rundown Live. So if we could begin this, begin playing this at the very start, please.
Kriston T. Harris here at the Rundown Live, and I'm here with a bunch of militia. They're protecting a local car shop across the street. I saw yesterday as this one, there's video of it on YouTube, of this one burned. And we have that fire and people are hitting it with bats and a whole bunch of other things.
I have an objection to this audio being played and the editorialization. I don't have a problem with the video being played.
I think we've agreed to the authenticity of it. I think that the individual who recorded this is available to be subpoenaed if necessary.
Well,
I don't think it's.
There's a rule of confrontation.
May we approach, Your Honor? I don't want to continue this in the presence of the jury.
Well, start there. Start from that position and we'll see. It's a confrontation issue.
May we approach, Your Honor? I'm sorry. It's
No, because if it's it'd be something that has to be a record, and I'll have to send the jury.
It's
on
not, I don't believe it's a confrontation issue, Your Honor, because we're going to be here, we've already heard audio from other witnesses, and we're going to hear more.
There was not an objection. I can tell you. If there's descriptive material, then he's entitled to confront the speaker.
There is not descriptive material of the defendant, Your Honor. This is not a confrontation issue.
You've heard it before?
Yeah, I've seen it in its editorialization.
He's already made statements, assertions of fact.
He just made one.
He did.
Okay, we can play it without the audio. There will be times in which we will have audio of interactions with the defendant, where he makes
That
statements.
Defendant's statements are admissible.
All right, I'll do my best to alert you when those occur. So let's play without sound for now.
When I studied evidence last century, the evidence textbook, which was probably about this thick, about a quarter of it was dealt with the hearsay rule. You hear the word hearsay all the time, and the section on the hearsay rule began, there is nothing murkier in the law of evidence than the hearsay rule. And I can tell you from 50 years of experience that that is accurate. It is a rule that has many, many exclusions, and it has many, many exceptions. So some things that may seem to the untrained ear to be hearsay are not, and some things that don't seem like it are. Basically, the rule is that a statement of a non-testifying person cannot be offered to prove the truth of the matter which is asserted in the statement. The rule, this is something we actually referred to on the first day when I talked about what's introduced in evidence has to be under oath. It has to be subject to cross-examination. And that's not true of statements that are made by somebody who's not here while testifying as a witness. He's not here on the stand, he's not under oath, and he's not subject to cross-examination. So this person who's describing this is occurring on a discussion that you or I might have if it didn't require the strict rules that we have in the courts, perfectly, ordinary conversation. But when it gets into court, and this is actually referred to in the Bible, St. Paul, when he was put on trial, in this is, I think it's Caesarea. Well, it was over in Palestine, in Israel. He was accused of some activity, and he was a Roman citizen, which was not common, but he happened to have been a Roman citizen, and so he had rights that we share now as Americans. And when they tried to put him on trial with evidence which was being repeated by somebody who wasn't there and under oath, he said, "Where are the witnesses against me? I am a Roman and I have a right to confront my accusers. They should be here." And so that led to actually his voyage to Rome to have his case heard before the emperor. So it's an ancient rule. It's strictly enforced in the criminal courts for very obvious reasons. So that's what we're talking about here. And so if the person who's making this descriptive material is here and can be put under oath and cross-examined, then it's admissible. But otherwise, it is not admissible through the officer here. You can play the video. And now, one of the exclusions from the operation of the rule, there was reference here to there were apparently statements, the state claims were made by the accused. There's an exclusion. That is not hearsay. A statement made by a party opponent is not hearsay. So the district attorney is entitled to have the sound up during those if they are statements of the defendant himself. So, go ahead.
All right, we'll continue the video without sound. There will be a moment in which, shortly, where we'll turn the sound back on. But for now, we'll just play without sound. Pause for a second there. Detective Howard, have you had an opportunity to watch the video we've been playing so far?
Yes.
Okay. May I set up that easel again, Your Honor?
Sure.
Thank you.
Yep.
Detective Howard, based on what you've seen in the video thus far, are you able to identify the location of where this video is being taken?
Yes, the videographer at this point in time is on the southwest corner of Sheridan Road and 59th Street. It looks like he's in the Car Source parking lot. I'd say about there. The viewpoint of the video is pointing north towards St. James Church.
And we've already heard some testimony about the fact that St. James Church on our map looks like it's got a structure there, but in the video it's changed. Are you familiar with that?
Yeah, St. James Church at this time, and a little bit prior to these incidents, was going through a demolition.
Okay. Thank you. Please.
Well, the former school building,
Yeah. Yeah, the school building,
not the church.
correct.
Let's continue the video, please. Let's pause 1 second here, and can we turn the sound back on? I think everybody's in agreement. That is the defendant, correct?
Yes.
Okay. So let's turn the sound back on briefly for this section, please.
We're live, got the rundown live. And as you can see, there. Do you have a good angle? Yeah, very cool. And you guys local or no? Yeah. Okay, cool. No, we'll do this.
Coronavirus.
Oh, dude, I'm not afraid of no coronavirus. In fact, my shirt underneath, it says, I survived the coronavirus. There you go. Yeah, it's very possible. Was that?
I'd be safe and dangerous.
Oh, bro. Believe it or not, I've been doing this for about 12 years, so 41. And, you know, if you guys see me get hit with something, I'm knocked out, that's when I need help.
Yep.
Or if it looks like somebody's going to beat me at the club, then I need help. Other than that, I can...
We'll be there to help.
Non-aggression principle. You know, I don't want anyone hurt. They have medics too, and their medics are pretty helpful, even though they might be on the other side, if that makes sense. But they'll help me, okay?
We got medics too.
Okay, cool. So, are you guys? Do you guys mind?
We'll turn the sound off now, but continue the video. Thank you. I'm sorry, I misspoke. Let's go back a few seconds and turn the sound back on. There, let's continue with the sound at this moment for a little bit, please. Thank you.
They have medics too, and their medics are pretty helpful, even though they might be on the other side, if that makes sense. But they'll help me, okay?
We got medics too.
Okay, cool. So, are you guys? Do you guys mind? Is there a way up on the roof? Okay, no, that's fair. I thought I'd ask and make for some cool footage. But we got militia members.
Let's turn the sound off now, please. Thank you. We pause the video for a second there. No dispute on. Okay. I'm going to use. May I use that sister? What's her name again? I'm sorry. Marciana. I always started to say Marcia. I'm going to point out up on the roof there is Dominic Black. And there's not any dispute about this from the defense, so I just want to clarify for the jury. I'll do it on the screen here if I can. This individual here, which is the one with the lighter shirt on, is Dominic Black. No dispute on that? Okay. So that is Dominic Black up there on the roof. Thank you. Now, can we please skip forward to the 30-minute and 25-second mark? All right, let's continue. All right, thank you. Can we play from there? No sound at this moment, please. Pause for a second there. I don't think there's any dispute on both. For the jury's purposes, I'm just going to point out this individual that is going to be walking towards the camera is Ryan Balch. And then we just saw the defendant on a car that was leaning against a car that was off to the right of this. So he may come back into view again, but just wanted to point that out for the jury. Please continue. Can we stop 1 second, please? Can we go back to the point where the defendant comes into view and turn the sound on, please? Right there, please. Pause and let's turn the sound on, please.
All right.
Who's a fast runner?
Oh.
Run down
Yeah,
there,
don't instigate. Don't just stand there. They're not going to cause any problems. So we got the militia here.
Stop. Sorry. Turn the sound off, please. Thank you. All right, let's go to the 48-minute and 45-second mark, please. Okay, can we turn the sound on for this, please?
We talked to them a little earlier, and they've been pretty nice to me. They've kind of let me come and go. How you guys doing?
Hey, where you at?
The Rundown Live. So,
Got a reporter in the perimeter!
all right, they're saying I'm in the perimeter. They're making awareness that I'm here. All right, they're asking me to leave. And we got the militia here. They're trying to protect private property. They're trying to protect their property. Everyone got that right. Yeah, no shit. I don't disagree. That's I
Hey,
think
they
their
aiming at
property.
us when we down there
Oh, were they?
with the green laser.
Oh, I didn't know
Yeah,
that.
with the green laser.
That's bullshit.
Yeah.
No, that's not cool. But I think a lot of them just are scared. So
Look at these pussies on the roof!
they're just trying to protect their property, bro. I agree with this guy. These guys just trying to protect their property up there. Yeah, they're just trying to protect their property.
Oh, yeah, I know, but they...
Like, if that was my house and I didn't know what was going on, I'd be, you know... Yeah. Well,
I just assumed they were like some old riders.
no, I think one of them, they clicked the laser pointer, and they're probably somebody's trying to be a copy dick.
They got the right to do that.
Yeah, I know, but it's still being a copy dick, though, you know.
That's true.
Because those things are loaded. That's not for fun. That's not for fun. That's not painful. But they got, you know, yeah. Back to my point, not all militias should have guns, because if they're pointing lasers at people from the roof, that's not cool either. So that's what caused it. So allegedly, the reason why they were upset is somebody pointed a green laser at them from the roof. So they, you know, those are loaded guns, so people will think that. De-escalation. That isn't de-escalation, you know.
It's the same as the earlier objection. If he wants to play my client, that's fine, but this is editorialing.
I understand the objection. The problem is there are portions of this that don't have anything to do with the defendant that describe the scene, and I'm trying to give the jury
That's
a sense of the
hearsay.
scene.
It's hearsay.
I'm not introducing anyone's statements for the truth of the matter asserted. I'm introducing it for the state of mind of the defendant as he watches
If
the
it's
scene.
not for the truth of the matter asserted, it's irrelevant.
No, it goes to state of mind, Your Honor,
State of mind of
of the defendant. When he sees
someone else's, would you do me a favor and step into the library for a minute? Please don't talk about the case while you're out of the room. Okay, first off, the Court of Appeals very strongly condemns sidebars, and we've used them for a number of purposes in this case, which I think everyone would agree have not touched anything which is an essential part of the case, and mainly have been management issues. But the Court of Appeals rightly wants to have a full record made, which cannot be made when we're having a little sidebar. So, and when you state your objections, then I've stated you have to state the objection here, or else I'll have to excuse the jury. And I think we're going to get into this a little more deeply now. So I think we did the right thing to do that. And I will try to keep it so that they're not inconvenienced too much just being in the library here. No, let me just set the stage here. I've talked about inaccurate things out on the media, and one of the things that I've read over and over and over again is about how I messed up the State against Jensen case, which is now pending downstairs. Actually, I had it 100% correct in the first place. I ruled that the disputed matter was testimonial evidence that had to be confronted, and your office appealed. This is 20 years ago, and it was fine. It was a big issue. It was a big case, and the state Supreme Court reversed and said, no, we're going to adopt a new rule that is to be applied in this case about waiver and forfeiture. And so it came back, and I said right in the record, this is going to get reversed again because it was an unsound ruling, unanimous. I hate to say that about the Supreme Court, but it's true. And of course, that has proved positive. So I tried the case according to the way the Supreme Court told me to try it, And that was 20 years ago. The man is still in prison. And the case has again been reversed because of the evidence that the Supreme Court told me to admit. I don't want to mess around with confrontation issues. I can't let you present evidence into this record, which is barred by the Confrontation Rule. And you're asking me to let this just run while this man is making descriptive materials to prove the state of mind of the accused? That doesn't make any sense to me at all.
First of all, Your Honor, nothing that's being said in this video can be construed as testimonial.
There was historical information that he was saying in the part that we did here.
It is not for testimonial purposes. He is not presenting it in anticipation of litigation. He's not giving it to law enforcement. It's not a report for the purposes of reporting a crime or for any pending legal action whatsoever.
He's making, well, even, okay, let's not even talk about it as confrontation. Let's talk about it as hearsay.
Then it goes to the defendant's state of mind, because the defendant is witnessing everything that's going on in this video. He is witnessing what's going on in the crowd. He's witnessing the response. He's witnessing all of these statements that are being made. And it goes to his state of mind. It's a present sense impression. And the defendant's state of mind, as we've all agreed multiple times in this case, is critical to the case.
Your Honor, start at the beginning for where I came in. The state argues that we've been doing this. One, Mr. Elijah, who was giving the editorial comments in the first video, he was here to be questioned. In this case, this individual who's in charge of the audio-video feed is not under the state subpoena. He could be. If they chose to do that, they could have him here, and he could testify to his opinions, and we could cross-examine those. That would be acceptable. What Mr. Binger is saying is, my client is there, so he knows all this. There's no proof that what that individual is seeing, filming, and commenting on, my client is looking at it, seeing, or part of it. That's why that person needs to be here to testify. I have no problem with this detective testifying as to people, places, and things from this video. We stipulated that. I did not stipulate to the editorial comments. I have no objection. Obviously, there's no basis for it when they want to play statements of my client that are on video. That's not hearsay. But this and his statements regarding militia, things like that, that is hearsay.
So we've got two complaints here, or two objections. One is the confrontation clause. This is not testimonial. It doesn't even fall anywhere near testimonial. Therefore, confrontation clause, I don't believe, is a valid objection. When it comes to hearsay, Your Honor, we had a pretrial dispute regarding things that Joseph Rosenbaum did all night long that were not witnessed by the defendant. The defense argued that those things should come into evidence because they show the context, they show his character, they show propensity for violence, they set the scene here. And I argue to Your Honor that if the defendant didn't personally witness it, it shouldn't come in. That argument failed. You allow them to come in. We've heard in the opening statement a lot of things about Joseph Rosenbaum that I know personally, and the evidence I think will demonstrate that the defendant never witnessed that night. But they're going to come in to attack the character of a deceased individual. And I understand the Jackson ruling. I've read that decision. I understand all of that. The difference is, Your Honor, this is exactly what the defendant witnessed. He is right there. Now, counsel is asserting that the defendant isn't aware of what's going on at this scene. I don't know that. The defendant knows that.
Well,
he has the right to testify. I'm going to,
Wait a minute. You're right, he has the right to testify. He has no obligation to testify.
Absolutely not. But if he's going to get
And if you're going to,
he is present. He's within a few feet of all this stuff going on. So it is a perfectly reasonable understanding that he is witnessing this and that this is forming his state of mind. He is seeing confrontations. We are showing the jury those confrontations. These are occurring right in front of his face. So this is him right there. I'm not showing stuff that was 10 blocks away. I'm showing what was right in front of him as he's witnessing. We've already seen him in this video. Now, if the defense wants to argue he didn't witness it, if they've got evidence to suggest that, they can argue that and the jury can make a decision. This is a factual dispute. The hearsay objection Again, these are not being, no statement that I'm showing this for you is being offered to prove the fact of the statement. But hearsay does not necessarily have to be admitted for the truth of the matter asserted to be relevant. It can be admitted for other purposes, such as present sense impression, state of mind. These are excited utterances that are going on in the heat of a conflict in a
Let me
scene like
interrupt
that.
you
So there are
because
plenty of hearsay
There are so many
objections.
things you're touching on that I want to be able to tackle them all.
Sure.
And this present sense impression thing, what the defendant was aware of with respect to what was pictured in the video, and I'll give you that even though the camera's aimed on him and is looking into his face, and what he's seeing is actually the videographer, but I'll grant you he's there, but you're accomplishing the result as to what was available for his scrutiny when you show the movie, the video. I don't see where the commentary by the videographer is part of his sources of knowledge. That's number one. Secondly, getting back to the Jackson case and the ruling the other day, and I'm going to comment about the media again, because there was a gentleman on TV night before last who said this is the most divisive case in the country today. So anything that undermines public confidence in what happens here is very important. It's important for this town. It's important for this country to have people have confidence in the result of this trial, whatever it is. And I don't care what it is, but people have to be confident. There are people on the media, on reputable sites, that are saying things that are totally bizarre. And I'm going to cite one only because it is exemplary, and it stems from the conversation we had the other day about the uncommunicated threat rule. You talk about things that occurred with respect to Mr. Rosenbaum that were unknown to the defendant at the time that the crime allegedly was committed. And you're right, under one subsection of that statute, the defendant has to have been aware of the incident in order to be an operative fact. But there's another one, the uncommunicated threat rule, which is an ancient rule of our law, which I talked about at the time of the ruling. And the Jackson case discussed it somewhat. It's also discussed here at Judge Weinstein's commentaries. And it's section 7.01, subsection 3, subsection C. And it says, if the defendant offers evidence of the alleged victim's character, it must be in the form of opinion or reputation testimony. And that was, I think, one of the things that you were advancing. It may not be in the form of evidence concerning other acts. When a defendant offers evidence of the alleged victim's character, then the process, well, I won't read that because it's not relevant. But then the next paragraph, and this is the critical one. When the defendant offers evidence of a homicide victim's violent character, but does not show that the defendant was aware of that character trait at the time of the incident resulting in the victim's death, the defendant is offering the evidence as circumstantial proof of the alleged victim's violent behavior at the time of the incident in question, and the offer falls squarely within Rule 404, subsection A, subsection 2, subsection B. On the other hand, if there is evidence that the defendant was aware of the alleged victim's violent nature at the time of the incident in question, evidence of the alleged victim's violent character is admissible in support of the accused's claim of self-defense, but solely under 404A2B. Under those circumstances, the evidence of the alleged victim's violent character is admissible independently of Rule 404A2B because it is relevant to the accused's apprehension of the imminent danger and the reasonableness of his or her defensive measures. So there's two different parts of the rule. One of them is the defendant has to have been aware of the decedent's violent acts or turbulent behavior. In the other one, it's circumstantial evidence of the victim's violent behavior at the time of the incident. That's what I admitted it on. Now, one of these, this was on CNN, Jeffrey Toobin and another attorney there, and the comment was made that the ruling was incomprehensible. And I think they obviously are not familiar with this rule. That's our law. That's the law in the Jackson case. It's the law in the case of the United States against Craig A. Smith, which is 230 Federal 2nd 300, 7th Circuit case from 2000. This is admissible evidence. But it applies under the statute to the decedent. It does not apply to the defendant. So you're mixing rules up here, and I don't understand any theory under which you can bring in what certainly seems to me to be hearsay when you could acquire the attendance of the witness.
Judge, there are two things. Do you have the modern site, an actual site for Wisconsin in terms of the rule? Because that 404 clearly is not a Wisconsin statute.
Well, I'll look it up. It's the same rule. It's 90404.
904?
It just changes one numeral, which has been the rule for as long as I've been practicing evidence.
What was the subsection? You said 404 subsection 2B2, was that it?
Yeah, it would be Wisconsin. The federal rules and the Wisconsin rules, as you know, have basically are the same in most instances and in this one, but they just use a different numeral.
That's the greater latitude rule of child sex offenses.
No, it's not. It's not the greater latitude rule.
Well, under 90404 sub 2B2, that under Wisconsin statutes, that's the greater latitude rule for child sex offenses. So the greater latitude rule for child sex offenses, there may be a difference in the subsection lettering and numbering between the federal system, which is
There
Rule
is.
404, and Wisconsin statute, section 904.04. So I'm not sure where that section that you were mentioning, Judge, matches up with the Wisconsin statute. I think that is Mr. Krause's point.
All right. 90404, character evidence not admissible to prove conduct, exceptions, other crimes. And subsection, you know what it is? They changed not only the first digit, but they also changed the A's and B's to 1s and 2s. So you're right. I was reading from Judge Weinstein's commentary, but when you translate into Wisconsinese, it comes out as with numerals. But it's it's 90404 subsection 1 subsection B, and evidence of a pertinent trait of character of the victim of the crime offered by an accused and then under 90405 methods of proving character is subsection 2 is specific instances of conduct of the in this case the decedent.
I understand, Your Honor.
So that's the basis upon which this ruling was made. and it's not incomprehensible, and it's accordance with our law. And what is in the mind of the defendant is not governed by that rule. This is the character of the decedent.
I understand what you're saying, Your Honor. I want to briefly respond to that if I
Yeah,
may.
be my guest.
And then I'd like to get back to this video. I think just generally, I have not watched Jeffrey Toobin or anyone else discussing this case on the media. It is of no concern to me, so I'm not in a position to respond to what any of those talking
I
heads
don't
have said.
expect you to. My point is
Sure.
that I want the case to be fairly tried, and I wanted people to understand that we want to go forward from this case, whatever the outcome is, and not have all kinds of people making inaccurate statements about what the law is.
I don't have any comments on the media's coverage, Your Honor, so I'll move on. This video contains statements from the videographer and other people at that scene. The confrontation clause issue, I don't believe is
Skip
applicable.
from confrontation to
So-
a hearsay.
So let's go to hearsay. I am not introducing these statements for the truth of the matter asserted.
Then why are they relevant?
Because they go to the defendant's state of mind. They are
I'm
present.
going to invite you to respond.
Your Honor,
I'll hear you more, but I do want to hear his response.
unless this unsubpoenaed individual can read minds, that is a ridiculous argument. This narrator is going to prove my client's state of mind? That's absurd. I don't know how to respond to that. And the general, and I don't even want to use this word, but panoply of what's going on here, if it's not the opinions of the narrator, that goes to what may or may not have been seen by my client. You know, somebody yelling, they're throwing things, or there's a laser. I'm not objecting to that, because that's part of what goes on and what went on that night. It was shown, even some at the gas station that Mr. Elijah was testifying to. What we're objecting to is the person who is running the feed and giving the editorial comments. That is hearsay.
Can I just ask, maybe we can short circuit this a little bit? What specifically is this person saying? Is it the word militia? That's I think, the triggering word here.
It seems to me you have the burden to tell me what that I should expect from this video that I never heard before, how I should be ready to pounce, because you're offering a running commentary from a person who is not here under oath to give testimony, and you're expecting me to be ready at a moment's notice to figure out what's going to be the next word out of his mouth, and then try to put
My question was actually directed at the defense, Your Honor. I didn't mean to direct it to
well,
you.
all right.
So I think the difficulty practically, Your Honor, I understand the objection of the word militia, and I don't think it's hearsay. I think it falls within a number of exceptions, but nonetheless, if we're going to deal with that word, I guess there's a couple of options. One is I can try and go back, and I'm going to need some time to do this. I would need to go through this video and figure out every moment that that word is used, and we will have to figure out a way to cover that up, stop the sound for that second that that word is used. The other option is, and I think this is a perfectly reasonable one, is the judge, you can simply instruct the jury on this issue, that this is the narrator's statements. They are not to be, that the jury should give no weight to what the narrator is characterizing.
I've never done that before. In 50 years, well, in 38 years up here, I have never told a jury, I'm going to play this, and some of it might not be okay, but just don't pay any attention to that. Is that what you're telling me?
I respect the fact that you've never done it, Your Honor, but it has been done. It is a perfectly permissible procedure by the court. The jury is presumed to follow your instructions.
Yeah,
We give them instructions on evidence all the time.
We're going to take a break right now. Would you ask the jurors to go upstairs and talk about the case, please? We're going to take a break. I think it would be prudent to do so at this point. after.